So I have to preface our presentation because I'm so excited about what I heard from Supervisor Horvath, because she said some things about treatment that public officials won't go near. She actually mentioned involuntary care, medically necessary treatment, specifically subacute and acute care. I've been doing this work a long time. My son was arrested in November of 2002, and that started this journey. And through the years, I've seen lots of reasons people with mental illness end up entangled in the criminal justice system, but the single biggest contributor, if I can use that word, is the lack of access, not just to mental health care in general, and lack of access to outpatient treatment, but specifically for the people who are the most seriously ill, the lack of access to subacute and acute care. And those are the people that are incompetent to stand trial and can't get out of jails. These are the people that are languishing in state hospitals. These are the people that are homeless. And these are the people that are revolving through our system and our jail cells over and over and over again. So to have Supervisor Horvath come up and discuss that it's a good thing that we're getting more subacute or acute care, that it's a good thing that we're providing medically necessary treatment, and even if it has to be involuntary in order to stabilize someone, that used to be viewed as, by patients' rights lawyers, as an abridgment of people's rights. And the county is evolving because now our leadership in the county is realizing that that's medically necessary treatment, and that without it, people will end up in jail cells or homeless or in prison. And the fact that she said it and said it publicly is a big deal. And I told her that. So it's really exciting because it is connected to criminal justice. I wanted to do something different. Last year, we brought on different panelists. Caroline Goodson was one of them. And we talked about the different pathways to diversion. And we got into the specifics of how program works. Today, I wanted to do something really practical because I get calls all the time from family members. My family member's just been arrested. I don't know what to do. My daughter's arrested. My husband's arrested. And they're in jail. The family doesn't know how to help. They don't understand the chronology of a criminal justice case. They don't even know what diversion is. They don't know how to access it or what to do with it. And I have spent, I don't know how many hours over 22 years explaining the system to people. And we wrote a guide back in 2003 called My Family Member's Been Arrested, What Do I Do? That was written by, thank you. That was written by, I'll give credit where credit is due, Carla Jacobs. For those of you who've been around a while, know Carla, Jim Randall, and myself. We were the co-authors of the original, and we updated it. I updated it in 2015, but it's now pretty seriously out of date. And with that comes an inmate medication information form, so which we'll talk about later, so families can actually provide clinical information to jail mental health. But I really wanted to provide something practical. And I'm going to make a rule, okay, a little housekeeping rule. This is not going to be she's a head public defender of our rapid diversion program. We're not turning this into a criminal justice support group, and you are not allowed to talk about your personal cases, either with your own or your family member. So we're going to keep it in the area of public policy and public protocol and law, but because it's just inappropriate to do it in a public setting. So I want to tell you, first of all, my name is Mark Gale, and I'm Criminal Justice Chair for NAMI Greater Los Angeles County. Been doing this work a long time. I was Criminal Justice Chair for NAMI California for 5 of my 6 years on the board, from 2006 to 2012. I'm also with Judicial Council's Collaborative Justice Advisory Courts Committee, and Judge Manley, my hero from Santa Clara County, Judge Manley's Mental Health Subcommittee. And I was on the original task force that wrote the 137 recommendations on how to bring a mental health court to your community. And in LA 20 years ago, we would go to the presiding judge and county leaders, and we would say, we need mental health courts. And the answer we got is, we will not have any specialized boutique courts in our county. Forget it, NAMI. And this went on forever. My son was arrested in the big bad days back in 2002 when there was no diversion program other than 50 beds at Olive Vista and Pomona. Those are subacute beds through the DMH court linkage program, which has been around for 25 or 30 years. Without that, my son would have gone to prison. And he committed serious crimes. There's no joke. I don't excuse what he did, but what he needed was treatment, not CDCR. We have grown. We are leading the country. Caroline and I were just talking. She just came back from New York City. They don't have diversion programs. We do. Other communities in other states, even states who are far-reaching and they're thinking, like Colorado, state of Washington, they look at what we're doing. Nobody has an ODR, an Office of Diversion Injury. Nobody has a rapid diversion program that Caroline heads that she's going to talk about. But I wanted to just do help for families. Okay, if you've got a case going in your family and you don't know what to do, what happens? What's the timelines? What's the chronology? What can I do as a family member to help my loved one who's entangled with the criminal justice system? Caroline Goodson has been nice enough to come back this year, and she's a Los Angeles County Deputy Public Defender and the founding program manager of the Rapid Diversion Program, which is a mental health diversion program. And diversion means we're going to divert somebody from incarceration to the treatment, from the criminal justice system to the healthcare system. And this is a diversion program that reaches 1,500 defendants annually across LA County. In her 17 years as a deputy public defender, Caroline has handled felony, misdemeanor, and juvenile cases involving both violent and nonviolent crimes. She was instrumental in 2019 with the creation of the Rapid Diversion Program and its subsequent expansion from just misdemeanors only to felonies and into 7 courthouses throughout LA County. In 2024, she was given an award by the Los Angeles County Bar Association for being the Defense Attorney of the Year for her work on the Rapid Diversion Program. That is a big deal. And in her current role, she is responsible for overseeing and stewarding the Rapid Diversion Program for the public defender, managing the program internally while shaping policy and procedures and strategy, expansion planning, operations and collaboration with JCOD, the Justice, Care, and Opportunities Department. I don't know when she has time to go to court. As of September 2024, the RDP has diverted more than 2,500 clients and boasts over 700 dismissals to date. Caroline received her BA from Emory University and her law degree from Loyola Law School. So she is going to run through what you do when your family member has been arrested. Caroline Goodson from the Public Defender's Office.
Thank you so much. I'm so happy to be here with you today. So I want to talk just briefly about what happens when your family member has been arrested and they have mental illness, right? Because that's a really important thing. That's something that is key to what is going to happen to the case. And so I want to talk to you about some practical considerations that your public defender, the family should be thinking about as they run through the criminal process. So first, I want to talk about how does an arrest happen? Because I think most people think that an arrest is what you traditionally see on the news, right? Someone's stopped, they're put in a police car in handcuffs, they're taken to jail. Yes, that's an arrest. But arrests can also happen in other ways. For example, if a family member is stopped, they can often be given a citation to appear in court. That's also considered an arrest. And I think it's really important for you as family members to be aware of this, because you shouldn't just be asking your loved ones, have you been arrested? It's also, have you been stopped? Were you given any papers, any information? Because I see it happen all the time where people don't realize that that was an arrest, don't appear in court, and they get a warrant and now they're in jail. And that's just going to complicate things so much more. So please ask that further question if you hear about any kind of involvement with the police. Did they give you anything? It can also be where the police officers go to court and ask for a warrant. In that case, what they've done is that they've mailed the family the last known address, information about the person appearing in court. If you get something official, I know you don't know this, but this is so important. Have the person appear. It doesn't just go away. It will come back to haunt them. And again, being in jail makes everything 10 times more difficult, especially for our mentally ill loved ones who end up really decompensating once they come into jail contact. So while we talk about what the police does, the prosecutor also plays a really important part, right? Because what the police are doing they're just making recommendations for what should happen. It is the prosecutor who's going to make the decision about what is going to be filed, if a case is going to be filed, what type of charges. So I hear a lot of comments, well, that wasn't what I was charged with. Well, they can use anything that's in the police report to formulate what they think legally constitutes a charge. They can also make a decision about what kind of charge level. Should it be a misdemeanor or a felony? So really the whole process is the police and prosecutor making that decision before someone goes to court. Mark, any questions you have about this?
Yeah, so a real basic one is give it a couple. Okay. Anyway,
Let me see.
we're all, you see this like on television and stuff all the time. Can people talk without an attorney present? Can you talk about that a little bit? Because, police ask questions. Gosh, people talk to them. Talk about.
If you're being accused of a crime, you should never talk to a police officer. It will not help you, especially if you're mentally ill. You're not able to put your words into proper sequencing. It can lead to a lot of confusion. You should talk through your attorney. Your attorney can explain everything that happened. Do it in a logical way, a way that's not going to have consequences. The problem that we often see when people want to explain themselves away, especially when someone is dealing with a trained police officer who often is trying to get a point across, may not understand that the person has mental illness and may end up leading to a conversation which really doesn't lead to any productive information that's going to be helpful to the client coming out.
So do you think it's right for people to disclose that they have a mental illness diagnosis? We think when you go through triage and in-rate reception into the jail, you disclose to the nurses that you need treatment, obviously, but there are situations that happen before that.
Yes, I would just limit the information that's given. And this comes from a public defender perspective. I think going to triage in the jails where they're there to actually help you and actually provide medication is quite different than when it might be used against you to formulate a more serious criminal case.
So use some discretion.
Correct.
Okay.
And I just want to make sure that we're in order. Okay, Mark, I'm going to turn this one over to you.
You are? Okay. Got to be able to read it. Supporting your relative. Okay. So, I got that phone call, which, hey, Dad, I got bad news. So if your family member calls to say they've been arrested, help them stay calm and offer your support. I'm going to use that later, though. Don't take it away from me. It's the dance of the microphones. Remind them of their right to have an attorney present if questioned by the police. Right? We were just talking about that. And to not discuss what happened with anybody except your attorney. Okay? And that's something I think everybody's familiar with. At the local jail, there's a number of things you can do. You can call the watch commander and describe any illness. This is in the city jail. Remember, a lot of people are arrested. They go to the city jail on a Friday night. They're arrested. Monday morning, they're put in the bus, taken downtown to inmate reception. And now you're in the county system. So at the local jail, you might call the watch commander if they really need medication, either for a physical medical illness or a psychiatric illness, to see if the local jail will allow you to bring medication to your loved one. Obviously, they will ask those questions when they get to Twin Towers. Chris, do we have the form handy? Okay, we'll show you. So in 2003, I developed something called the Inmate Medication Information Form. It is on the sheriff's websites. It's on most NAMI websites. And it also has been adapted by 15 other counties across the state. And it's basically medical and psychiatric information to provide for families to provide information to jail mental health and sheriff's medical bureau. That did not exist before my kid got arrested. And what I saw when I would stand in line to go visit him was all these families were writing notes on the back of napkins and toilet paper because he's on the wrong meds. How do I tell the doctor what meds he should be on? So I talked to the deputies and I said, if you had a form the families could fill out and you send it upstairs. And they basically said, I'd kill to have a form like that. And we were just working with the sheriff's department back then, and we got it approved, and it's now part of the system, and it's on the sheriff's website. So invaluable. It's your ability to tell the doctors treating your loved one in the jail about your loved one. Assure them that it's okay to discuss their physical and mental condition, diagnosis, medications with the staff conducting the screening. When you're first arrested and you go into the jail, you will be screened. So now you're not talking to lawyers, you're not talking to custody, you're talking to nurses. All right. Tell them your medical issues or your psychiatric issues. And in order to access court information and find out where your loved one is detained, there's an inmate locator on the sheriff website with all the rules about visitation, et cetera.
Can I just add for the inmate locator, we as attorneys use that all the time. It is so accurate. Like it has to the time, to the date that someone's been released, arrested. It has their location. It has their next court dates, including what times. It is so helpful. It is something where if you need up-to-date information, that is where that's where I get my information. I know where to appear in court. So I would definitely, this is the first place I would check if I were you and you're wanting to know more information.
Do you want to pick it up?
Sure.
This is back in your group.
All right. Actually, I think you have a little bit more mental health information to give, but I can go through this if you want. You had talked about the inmate medication form, and Mark's provided some more information about when to use it. We also have on the form, you should include the full legal name, date of birth, booking number, location, why that they provided you a waiver, if any, ask them to sign it if not. Things that are helpful: diagnosis, psychiatrist, medications, the effectiveness of medications, history of suicide attempts, any urgent medical conditions. Don't go into the facts of the case. What they're really looking at is how do we medically treat the person who's been arrested.
And it's used. So 20 years ago, they didn't have electronic health records. So it was a paper form. So it would get to the clinician treating your loved one, but then we were never quite sure what happened to it. It used to go into a paper file. Maybe it went into a wastebasket. Now with electronic health records, we got the sheriff's department to actually, and DHS, scan it into the medical record. So because why is that important? Not just to preserve the information now, but a lot of folks get arrested multiple times. So if that same individual comes back, the information you provided to the Department of Health Services, Correctional Health Services, is still on the chart. Very important.
All right, so our first day of court, it's arrived. You're coming into court and you're probably wondering, well, what's happening on this case? Well, people are surprised to hear this, but as attorneys representing clients, we're seeing the information for the first time too. The way it occurs in criminal court is the police report comes into court probably an hour before the client arrives at court. So we really don't have at that point much chance to actually have gone through the case in detail. We absolutely look through it. We make sure that there's essential elements. But at the point that we're meeting your loved one for the first time, we're really seeing the case for the first time. And everyone has a right to have an attorney. I want to stress how important this is. Your attorney is your guide through the system. It's your advocate. They know all the complicated rules. They can help you. And so it's really important having one. And so if you can't afford one, one will be appointed in every single case. The purpose of that first court is really not to go into all the merits of the case. It's really the biggest purpose of the case is to enter a plea, not guilty, guilty, or no contest. But most importantly, it's to make sure that the custody status is determined. And like I said, that is a really important thing. And so it's a chance for the attorneys to argue whether or not this person should remain in custody pending the charges. And the judge will then make a decision.
You're probably going to not like this, but so families always say, how do I get to talk to the lawyer? I say, go to the arraignment. And once the arraignment's done, follow the attorney will grab their briefcase and head out the double doors. Follow the attorney into the hallway and say, I'm his dad. And see if you can grab them long enough. There's usually conference rooms off to the side, and see if the public defender will give you 3 to 5 minutes, because that's all you're going to get, and be respectful of that, to just say, where is this going? Oftentimes, a different public defender gets assigned after arraignment. You want to talk about that?
Sure. And this is something we had talked about recently, which is that actually in Los Angeles County and many of our courts, the person who's going to arraign the client is not the actual person who's going to defend the client. So while they need information, I don't want to minimize that. It's really important getting information. They don't need everything under the sun because they are not the person who is going to be handling the case for the majority of the case. Not in every court, but this is in a vast majority of courts. And so really by inundating them with a huge amount of information at that stage isn't helpful, especially when they're really looking mostly at how do I get this person out of custody? So what I had suggested, and we'll talk about a little later, is you're much better off bringing a piece of paper in with all the key information so they can look through that information, see what they need to make their arguments, and holding off on your later, more in-depth conversations until the assigned attorney is present. And I will add, your presence is important. I know from personal fact, having argued many cases to be released to many clients, being able to point to the audience and say there's a family member here, it makes a humongous difference. Okay, so
Which means we come back for the preliminary hearing and then we grab you.
that's correct. Because you should grab us and we want to hear it. And actually, so here we go. What do you need? What do I need? If I'm telling you what the most important things are that make a difference to me being able to really defend a case and help your relative, this one sheet of paper, if you can provide the date and location of recent hospitalizations or 5150s, that is humongously helpful. Remember, we don't have immediate access to medical records. We're starting at scratch the way the system works. And so anything you could provide gives us a jump start and starting to request everything. So names, dates, locations, treatment providers. While doctors are helpful, if you can even provide the provider, that makes even more sense sometimes. Locations, information re-diagnoses, information regarding medications, including dosages. A lot of the clients will be showing up and they're not medicated. If we can get them, we can request medication at that first date. That makes a huge difference in terms of their release. It's much easier to find placement for programs once they're medicated and stable. So that page of information, I would say, is key. I know that often families want to hand me like a life story, like a little novella about everything that's happened. And I just want to tell you that while it's appreciated, it's probably not as helpful as this one page where I can literally quickly skim and get the most bare bones information that's necessary. If there's things that I want to talk to you about and get information about later, we can pursue them later.
So you want to make sure that you got a booking number on the form, case number on the form, and the information. I always say, how many times hospitalized? Not for the last 15 years. How many times has someone been hospitalized the last 3 years? Who's the treating psychiatrist in the community, in case the attorney might want to speak to the treating psychiatrist in the community, or jail mental health might want to. As Caroline said, medications and dosages. Most of us have gone through family to family. So if you write schizophrenia, put a 1 paragraph explanation of what schizophrenia is. Maybe it's a new public defender may not know what schizophrenia and bipolar.
I'm gonna disagree. We are actually getting great training now on this.
This is good.
In fact, I just went around the county. I'm actually, in fact, doing the training. So me and our head social worker just recently went around the county. We have gone to every courthouse except for 2 at this point, and we have done in-depth training about all types of medical conditions. So this is something actually that the PDs are quite familiar with. So I think a simple diagnosis name is actually would be sufficient.
Please put me out of business.
So creating a relationship with an attorney, this is probably the most fraught question. And we've talked about this a bunch because I know that you're not going to be pleased by what I'm going to say, but I hope you'll maybe have some more understanding. You probably, if you've ever called the attorney, had them say, I cannot release any information. And I want to tell you that is by law. We are held by attorney-client privilege. We are not allowed to release any information, and we will not do it. And that no matter how much we want to help, it is a requirement and it's something we have to stand by. And even I would tell you that, for example, if I have a relative sitting right next to a client, I'm often not going to have that conversation with your relative in front of you. And it's not because I don't care and don't want your information or support. I don't want to make you a witness. I don't want you to be used in a prosecutorial manner later in the case. And so I want to hear what you have to say, but separately. And sometimes this can create a hurdle, right? Because what you're hearing is that I can't talk to you, and it's disturbing. But that's not all I'm saying. I can talk to you. I can listen to you. And I think that that is really what's key here that maybe is missing from this conversation. While I may not be able to speak, by being able to listen to you, I can gain such valuable insight into what's happened. And a lot of our mentally ill clients cannot supply the history that we need, the history of trauma, a family member who may have recently passed, sexual abuse history, traumatic events that happen, things that they're either unwilling or unwanting to speak about that may make a significant difference in what we proceed with the case. And so I just want to take this opportunity to encourage you, talk to the attorney, even though they can't talk back to you. You're still gathering something and making a significant difference in their case. Anything you want to add on this? Because I know this is
Oh, no, not after the last one. But see, this is good because the stuff I know happened a long time ago. The system's getting better. Now public defenders are being trained about diagnoses. That never used to happen 15 years ago or 10. So some of my information, of course, is dated. And I'm not a lawyer and I don't work in the system. That's why Caroline's here. Keep me straight and give us all the right info.
And I just, the third one I have here is supporting the client. You serve a valuable function, right? Because you know the person more than any attorney is going to. And just you showing up makes a huge difference. I can't tell you how my clients' eyes light up when they know. I mean, it's often one of the first things when I go in the back and talk to a client is anyone here for me? Like, it is a huge deal. And so I just want to encourage you, like showing up. I know it feels like a boring sitting, you only see a case that sometimes only lasts 5 minutes. It seems like you're not watching anything, but you're doing something. You're being present and you're being supportive. And that makes a huge difference to the morale of all of the clients, especially when they're in custody. And also even giving encouragement for case goals. While I wouldn't encourage you to talk specifically too much about details of the case while they're in custody, you don't want anything used against them. Even just giving them encouragement to seek help and treatment, because we have a lot of clients who are teetering on that decision. This is hard. This is hard stuff to make that decision to seek treatment. And just having an extra person, an extra voice saying, you can do this, it's going to be great, give it a shot, can really make a difference in them taking kind of a decision to make. And what we often say is the harder path. And I mean it in all actuality, because sometimes taking a plea is actually the easier path. Taking a decision to seek out treatment is a lot. And so we really want to encourage them to the reasoning for that.
Do you want me to mention about being family members going to court?
Sure.
So I always went to every hearing, and there were a lot of them. I spent 5 years keeping my son out of prison. And I always wanted the judge to know that dad was there, that he didn't have to play daddy, that dad was there, that if he was going to release at some point, the defendant, my son, back to me, there was somebody who was going to care and find him treatment. If there's no family in the courtroom, now the court has to become dad. They've got to use the county systems such as they are, all right, to provide whatever treatment. And I really think it made a huge difference. And I think it made a huge difference after he had served a total of a year, when they finally said, it's enough. Let's release him to his family, because they knew we were there. That goes without saying that I used to mutter things as district attorney, but I probably shouldn't say that in public. But I always made sure I sat right in the front row. And when they called my son's case, my body language, I sat up, the judge knew who I was. It's really important. It matters. It supports the public defender and supports your loved one.
I can't second that enough.
Can we take a question,
Yes,
Linda?
let's do it.
So going back to the last bullet point on the slide, so we can hear you.
Yes, sure.
I'm bringing it to you so we can hear you.
This one?
Yes.
Okay.
Giving our loved one encouragement for the case goals, i.e. treatment. So I'm hoping and I believe that things have changed since we had the experience with our son. It was during COVID. And, he had several trips to Twin Towers and was very quickly released. And they were misdemeanors. And we were at the point where we were praying for him to be facing a felony, because it seemed like it would take that to keep him in Twin Towers. And unless he was in custody long enough, he could not be interviewed to see whether he was eligible for diversion through the court linkage program. So I guess it's a long-winded way of saying, as a family member, our goal is that our loved one receive treatment, but and how we get them there.
They didn't want anybody in the jail. They wanted the population down, so they were releasing misdemeanors because they didn't want people dying in jail. But now with Senate Bill 1400, it's changed.
Well, actually, I would say that's exactly what RDP addresses, which is the program that I helped fund, because what we do is we specifically wanted to rapidly assess clients who were coming in. We actually specifically started with misdemeanors because we realized the time frame was so long towards getting them assessed, and it was just a revolving door. So we're actually at arraignment. So I'll talk to you about it in a few slides, but actually the treatment team is at arraignment and assesses the client at arraignment. Since everyone is arraigned, everyone has a shot at this program. Everyone has an opportunity. Does that mean everyone's going to take it? No. And one of the things with attorneys is we have to respect our clients' wishes. We can encourage them, but in the end, it's their decision. We're not there to impose. But we do have a role in terms of looking at a client and seeing that they're just coming in and out and saying, hey, try something different. Talk to this clinician, try a diversion. And by having the availability, that's really changed things. Having clinicians in court being able to give a diagnosis, immediately divert clients, they're more willing to take that opportunity.
So every defendant has contact with the RDP.
If they have mental health and they're open to treatment. And
Okay.
when we talk about open to treatment, they're open to even listening to it. So we try and be, and you'll hear that while we've assessed about 6,000 cases, we've only diverted 25. We do that intentionally. We'd rather have a wider net, so to speak, so that we talk to more people and give them the opportunity, as opposed to being narrow and self-excluding people. We'd really love to give them, the chance for them to self-determine.
Things are getting better. Question?
Comment.
Yes.
I wanted. Was going to need it. And the one page, hello.
You're on.
Having the one-page summary available for the arraignment attorney, for the prosecuting attorney, for not the prosecuting attorney, for his preliminary hearing attorney, was everything. And grabbing them afterwards and just being there, as you said, just my presence in the court, the judges would say thank you. And so everything that you've said is just spot on. And so thank you because you made.
Thank you for the comment. Debbie? We've got another question?
With regard to medication treatment and diagnosis at the initial phases, where is a clinician or someone able to evaluate someone to determine if they're gravely disabled, if they're able to have judgment to determine, what SB 43 will change in 2026 now? Who decides if they're capable of understanding?
Great question. We are going to go through that. We have a whole slide on competency because it is quite a complicated actually issue within the court system. So if you can hold off, I promise we'll get there. Did you have a question or do you want to? Perfect. So let me go ahead and I'll get there soon because as you see here, The most important thing for all of you here is the pretrial phase. It's the most important thing for an attorney. That's where the stuff gets done, right? That's where we're filing motions. We want to find out if the police officers have like a criminal history. We want to find out if there was a right to search, all sorts of motions. I could go on for days about the motions that we could file, but I'm going to focus on what are the things when I have a mentally ill client specifically, what am I thinking? And first to mind come these four things. These are the first four things that as an attorney, I'm thinking about when I see someone who has mental illness who's in one of my clients. Competency, whether or not there's actual defenses, whether or not there's a mental health diversion motion, and whether or not there's a plea with a probationary sentence possible. So we're going to go through each one of these. Competency. So a client is incompetent to stand trial. I have put the definition up here. They can't understand the nature and purpose of the proceedings. They can't reasonably assist their attorney. I'm here to tell you from a criminal law standpoint, someone can be very mentally ill and not be incompetent. I know it's very disillusioning to hear that, but that is what the case law says. So you can have active delusions and still be competent within the trial. And I've had it happen many times. Your active delusions must rise to the point where you can't actually assist with the case, not even possibly. You cannot actually. And so I want you to imagine how high that standard is. And so we often have many mentally ill people who are, still going through the system and not incompetent. Now, what happens if we see someone and we think that they're incompetent? Well, that happens quite a bit. If that process happens, either the attorney or the judge does what's called raising a doubt. If you've ever been in court, you'll hear I'm raising a doubt as to competency. What we're doing is we're signaling to the court, it's time to look into it. None of us here, none of us attorneys, we don't have the background and determination. We just see enough to suspect that someone with an actual expert level needs to make that determination. And so when the attorney in court actually raises this doubt, at that point, the case is sent to the mental health courthouse. And something we were talking about is that, just so you're aware, that's a whole nother set of attorneys that handle that. In my opinion, that's a great thing. Those are attorneys who are specialized in competency. It's a very, very different form of law. They're going to be handling the case for the duration of the competency proceedings. Same as those judges, the prosecutors. It's like a whole set of different people who are really based on that law, who are going to be overseeing the case as a determination is met, whether or not this person is competent.
And all that, it happens at the Hollywood courthouse.
Yes, correct.
There's no other courthouses that do.
No, there used to be the old Department 95, if anyone heard of it, but
Oh, yeah, the old pickle factory. Yeah.
yes,
But they closed that down, thank God.
Correct.
Much to the judge's delight.
correct.
But so if you ever hear that the case is going to Hollywood, there's a competency hearing. They also do LPS petitions and capacity hearings, things like that. But if the case all of a sudden pauses and they start talking about the Hollywood courthouse, then there's a doubt has been declared and they're going to do an evaluation from a psychiatrist
Correct.
or a psychologist, someone qualified by the court. And then that will be presented to the court to determine capacity.
Right, and your original attorney is not going to know exactly what's happening because really at that point in time, proceedings are suspended and until this determination is made whether or not the person's competent. So it's handed off to these other set of attorneys who are going to make this determination. And the way they do it is they have a psychiatrist who evaluates the client and basically says whether or not he thinks they're competent. And then there's usually a hearing where the judge will decide, is this person competent or incompetent to stand trial? So they have certain procedures. I will tell you, it takes a while sometimes.
You got 5 minutes.
Okay, so I got to run through some of these slides. If they're found incompetent, they're going to remain there, right? They're going to stay there. They're looking at MIST and FIST programs. If they're found incompetent, they're sent back to the trial courts and starting all over again. Let me quickly talk to you about actual defenses, because I know that whenever I have to tell people, family members, that I'm going to go to trial with a mentally ill client, I get looks like, are you yourself? Like, what are you thinking? And I want to tell you that our mentally ill clients have great defenses often, because our mentally ill clients can take advantage of, for example, insanity laws. And I'm not going to spend too much time here because those are really for serious crimes, but I really want to focus on intent. Most crimes have an intent, not all. And what intent means is we're not just looking at what the person did, but why they did it. And if your mental illness is creating a different why than maybe someone who doesn't have mental illness, that might mean that you're not actually guilty of the highest level of crime. I want to give you two ones that I have seen specifically. You know, for example, I'm going to change the facts a little bit, but I had a client who was accused of taking a watch and hit someone in the face, took their watch, charged with robbery. Well, it turns out he was in the middle of a psychotic break, thought it was his watch that had been stolen. And so we ended up going to trial and ended up showing that while he was guilty of assault, because that didn't have an intent, that's just an action, he wasn't guilty of a robbery because he didn't intend to take someone else's property. And so, huge difference. Another example, you probably hear about these types of crimes all the time where someone breaks into a house. We have a lot of clients who break into houses, running from people or things, not realizing it's not their own house. Again, is it a crime? Yes, it's still a crime to trespass on other people's property, but it's certainly different than a burglary where you're there intending to commit a felony. So it's a big difference whether or not they had the intent. I'm going to very briefly just pass on probationary sentence because in my opinion, this is the last thing I want to do. If I can do anything but a probationary sentence, fabulous. But sometimes in some serious cases we do. And so what I would tell you is this is again where the stuff you provide is so important. Any mitigation information you provide can make a huge difference in terms of us being able to convince someone. If I can be able to tell stories personalized, you know, police reports don't have any kind of real personal information, right? About the person, not just what happened that day, but what's happened in their life. That's so key to making a decision. And that's really where we can tell that story. My bread and butter, what I love the most is mental health diversion. I know last year I gave a big talk about this. It allows a client to be able to get diverted from the system, get treatment for 1 to 2 years, and get their case dismissed so it doesn't hang over them. And you see the qualifications. Most mentally ill people will qualify. There's several routes to diversion. There's structured programs through Los Angeles County. Like Mark told you, I went to New York and I was shocked at how well we are doing in terms of having actual structured programs. RDP, which I work on, is for moderate charges, mild mental health needs. ODR and collab courts have more high-level charges, higher mental health needs. This is a great thing. As Lindsay Horvath talked about, there's not one solution. There are many solutions out here. We need to be able to address people when they're at the beginning and when they're at the end of their mental illness phases.
So it's the charges that determine whether it goes through DMH court liaison or ODR or true mental health diversion.
Your attorney will decide based on the charges and also based on how acute the client is.
Okay.
Higher acuity will usually go towards ODR, whereas lower acuity will often go towards RDP.
Thanks.
And I would say this is where your attorney is very adept at being able to make these decisions. And often they fall between the cracks of these programs. And that's where we can do independent diversion. A attorney can file a diversion motion and create a plan. That's where we would use DMH linkage. We would use SENS, JCOD, DHS. The idea is make a plan that individually works for each client so that you can convince hopefully a prosecutor, but definitely a judge to let them out and give them the option of treatment. I'm going to let you, I'm going to leave it at this. I don't know if we have time for questions, but I think the most important thing I was able to really actually say last year was call us if you have a question. This is our main phone number. They are more than willing to tell you a case number, a date to come, who the attorney is. Use this phone number, contact us. Don't be a stranger. If you have a question, this is absolutely your opportunity to get in touch with the public defender. Any questions?
We got a couple minutes, Chris, or? Yes. Slowly, 15 minutes?
Yes, yeah, 15 minutes. Psychotic state, was in the streets when she committed the crime, charged with a felony. She's at the most extreme level of mental illness at Twin Towers, but they're medicating her. It's going to take some time. But by the time she has a competency hearing next week, she might seem a little more rational, a little more reasonable than she was when she committed the crime. Do they understand like the gap between that time? They're not going to judge the competency at the moment of the trial, right? Versus the moment that they actually committed the crime.
I hate to tell you, but it is actually at the moment of when the hearing is. And so we see this quite a bit, and this is the criminal court's rules. Whereas when you're looking at insanity, it's at the point of the crime. When you're looking at competency is, are they currently competent? So we see this quite a bit. And that's why you see, we'll declare a doubt and then 60 days back, the person's back. And often they're back because now they're medicated and able to talk to us. So that is part of that revolving door. Hopefully what happens at that point is being able to get them into a program, because when they're stable, they're at their most positioned to be able to get them into treatment.
But the competency factor is so important. There's technical descriptions, but it basically means that they can participate in their own defense, work with their lawyer, understand what their lawyer is saying to them, listen to the instructions from the bench, and understand what the judge is sending to them. And simply put, that's what competency is about.
And I'll tell you, I've had it happen the other way. I've been in the middle of trial, like the middle of witnesses, and I've turned to my client and been like, he's no longer competent. And I've had to declare a doubt and actually have them go to not the old Department 95. So yeah, it happens both ways. And it's something we're constantly having to evaluate because it's based on what is currently happening, at least for the court system.
As the brother, if I just show up, or I'm going to show up, will I be heard? Will I have a chance to speak at all and kind of explain who she is and give a little bit of history of the judge or the public defender, who I haven't been able to reach actually?
Usually you'll want to give this information to the public defender. They'll be able to best speak for you. Call that number that you have up there, find out who it is. I suspect what's happening is that you have the old attorney, as I said in the news. So
I have a name in theory, but I've left like 3 messages and I haven't gotten a call back
I
yet.
really want to address something,
Yes,
because
yes.
families do something all the time that I think is very wrong. You tell me
Yes.
if you agree with me. Mom or dad calls me up and says, I've written this long letter, I'm mailing it to the judge, or I'm mailing it to the district attorney so the DA understands he shouldn't file the charges. There's only one general on the battlefield, right? And that's the defendant's attorney, whether it's private or a public defender. So if you want to present information to the court and you want to make sure that the court sees something, it's got to go through your loved one's lawyer. They're going to make the decision whether it's positive for the case or maybe negative for the case. Maybe they don't want this information brought into the courtroom at this time. So don't write the judge. Don't write the DA. Speak to the lawyer about it. I used to go to court with like psychiatric profiles of my son with 4 copies, one for me, one for the DA, one for the judge, one for the clerk, one for the public defender. But I only gave the 3 copies to the public defender. So you wouldn't have to get anything. If you wanted to hand it out right then and there, you had 3 copies that you could work with. And if you didn't want to hand it out, you could just read it and put it in the file and use it possibly later. But don't start writing judges and DAs. Am I right or wrong on that?
speaking personally, not for the public defender's office, I will tell you how problematic this can be. Something that you think is helpful can actually prevent someone from actually getting treatment because they're now considered such a scary risk to the community. And so if really what you're looking for is the best way to get treatment, that is what your PD is there to try and help advocate.
Other question. I have a question about
Okay.
NGI. This is a tough one.
Ooh,
And I come across these and I need your legal expertise.
okay, we'll see.
So not guilty by reason of insanity, to my unlawyerly brain, means that at the time you committed the crime, and they're often very heinous crimes, oftentimes murder, there was violence involved, that when you committed the offense, you didn't know you were doing something wrong, that you were so psychotic and so ill that you didn't realize what you were doing was wrong. Is that the correct description of it? Or how would you put it?
I don't think I'm going to go into it in legal terms because it is so complicated, like the definitions, but you are along the right lines. It is broad strokes. It is, you truly at that time really didn't understand whether this is right or wrong. And that, let me tell you, is such a high standard. When people ask, why don't we use this more? It's a near impossibility. I mean, the vast majority of the time when we ask for incompetency, it's not found. So it's a really high standard to meet. It is something that is really reserved for the most serious cases and the most serious of mental illnesses.
Because sometimes people with mental illness, we all know, lack impulse control, anger management control, right? They're impaired decision making, terrible judgment. So you can be very, very ill, say experiencing psychosis. You do something because you just can't control your emotions and your behavior at the time. But then after maybe you've committed, you might run away. You might know, oh my God, I've done something wrong. That's not NGI. That would be different, right?
It would depend if you really truly understood whether or not at the time it was right or wrong. Remember, this one is at the time. So if you later improve and you're through medication get better, that's the opposite of competency. We're really looking at the moment of when the crime was committed. Yes. Oh.
The relative value of public defender rather than a private attorney?
You're asking me a loaded question, but I will tell you. I'll let you go ahead.
You know, some people have trouble understanding that the public defender isn't your lawyer, it's your loved one's lawyer, the person who committed the offense. So you want the public defender to answer your phone calls. You want to call twice a day and find out what's going on. Public defenders have unbelievably large caseloads. They don't have time to talk to mom and dad. Sometimes you want to play amateur lawyer and you don't think the PD's doing a good job. It's your prerogative to hire somebody. And obviously, if you spend a lot of money, the expectation is more access for whoever's writing the check. At the same time, most private attorneys are awful when it comes to the mental health system. They don't know the resources. They don't know about all the diversion programs. And the PDs are actually experts in that. So when, I always bring that to light. Don't discount just because it's a public defender and they have a large caseloads, don't discount the wisdom and knowledge that they have, because they actually do a really, really good job.
I'm thrilled to hear that, because that's exactly what I was going to say. The PDs really do have the experience. We see multiple cases. We're really familiar with the laws, the programs. Some of these programs, like my program RDP, is only open right now to indigent clients. They're really get the kind of training and background to be able to know what to do with these clients. And while there's wonderful private attorneys out there, the public defenders are expected to be experts at this. And I think that is something where you definitely, consider that.
You had a question.
I have a
Okay.
question.
The citizen's waiting a while.
To be transferred to California to serve out their probation.
It's possible. I've seen it happen. It takes an agreement by all sides usually. So absolutely possible. They have to make sure that there's the resources, that the court will accept it, that there's a legitimate reason. But absolutely, I have seen transfers.
We have time for a couple more questions.
Thank you. I have two questions. Gail, you said you attend the court, every court. That's what we did. But the first court day, they didn't allow us to get inside the courtroom. Only police and him. I don't know why. And then one of the police men, we are living in not the police, but what do you call it? Sheriff.
Sure.
Sheriff is area one, protect us. And then one of the sheriff who close to us, because we called a number of the time to the sheriff station, that one of particular sheriff told us, one of sheriff told a lie. It's not truth. So his sentence 2 years longer. But I don't know why we could not get in. but ended up good. He was sent to Patton State Hospital and come back. Second question is a Zoom.
Well, let's answer the first one first, because you.
Yeah, I
you-
do actually, I suspect this was probably during COVID. During COVID, they had emergency procedures where they did not let anybody into the court. I mean, it was basically just essential.
2013, so.
Okay, 13, I'm not sure. I have never experienced that before, and you should absolutely be allowed in a court.
I don't know why we were not allowed. Yeah. So anyway, ended up very good. He was sent to Patton, and then he was recovered pretty well, and we are very happy. Second question is a Zoom. How can loved ones get a request for the Zoom court to that mental health court? How can we?
I don't think you can. I think that's
LA
really the
County
lawyer's
does not
decision.
rely, and LA County does not rely heavily on Zoom. While we have some kind of Zoom appearances for like very minor hearings and continuances, LA County has really relied mostly on in-court proceedings, which I can tell you, I personally love, because I think that people need to have access to other people.
Yeah, very good. Court at the mental health Hollywood court. And then it was very successful because our name is on that screen, and end of the court judge said, family support is a very important.
But remember, the Hollywood court is not a criminal court. It's a civil court. The Hollywood court is doing LPS hearings or competency hearings.
Right.
And let's say you go to the Hollywood court and the evaluation is made and is determined that you are competent to stand trial. Then you're done with Hollywood, you go right back to the criminal court.
Mental health court, right?
It's a mental health court to determine whether you're competent or not,
Oh, I see.
or you have capacity to refuse medication, things like that. But the actual criminal trial is going to happen in Superior Court. Debbie, you had another question?
That someone is incapable of, doesn't have capacity to determine that they need medication.
Competency hearings.
So
So
only after
before
the
that, it's not, no one will be involuntarily medicated.
And so after the competency hearing, everyone then can be medicated involuntarily?
I believe it's the judge's decision, and this is something I think that you might be. able to-
Yeah, I don't think that you can, I've worked on these laws before in the past. You can't involuntarily medicate someone in the jail in the absence of an emergency unless they're in the FIP. So the forensic inpatient, the FIP, FIP, the forensic inpatient program inside Twin Towers is a 33-bed LPS designated hospital inside the jail. So within the LPS continuum, which is in the jail, not all jails have an LPS designated hospital. Because of our size, we do. So within there, you're going to, and that's really in the CTC, right? The Correctional Treatment Center.
This is way different
So-
from us.
Right, so this is where there's nurses, psychiatrists, you're essentially in an acute inpatient hospital with LPS designated authority. So if somebody's refusing medication there, they could deal with capacity to refuse in there. But if you're not in the FIP and they're waiting, there's always like a really long waiting list, 150, 200 people, and we got 33 beds. We've been fighting for more beds, I can't tell you, since the dawn of time. But if you're not in the hospital and you're just in a cell, they're going to offer you medication. They can't force it unless, I believe they can do it if there's a psychiatric emergency, but that's really extreme and really rare.
Mark, can I just give a closing remark very quickly? I just want to encourage everyone. Diversion works. I know the criminal system is really daunting, but I just want to let you know, we just recently did a RAND evaluation of our REP program, those 700 people who graduated. Over 91% of them did not have criminal contact with the system after they graduated. They can get help. There is a pathway forward. We need to be giving people a chance and helping them. And so I just want to give you like a last feeling of hope, because there is hope. We are doing things in the criminal justice system, and there is a way to kind of turn our clients and your relatives' futures around. So,
And since this is a NAMI office, thank you, Caroline, there's something else. You know, people with mental illness don't get well in a cell. And it's high time NAMI got louder and stronger about people with mental illness being transferred to treatment facilities, even though they're still incarcerated. So oftentimes somebody's too sick to go to ODR, but they would qualify legally if they were well enough to go to an open residential environment, but they're too psychotic, they're too ill. I've had judges say to me, boy, if I could step somebody up into acute care or subacute care, 30, 60 days, get them stabilized on their meds, have them do well, then we could step them back down from acute to subacute and then discharge them from jail and transfer them from the correctional system to the healthcare system, to ODR diversion or mental health diversion or whatever. We're gonna lobby for that. Okay, and it's high time that capability and that access was there. There are also people who aren't getting out of jail. They're serving 4 years or 5 years, or maybe they're a prison inmate who's still working on their case and it's spending years in the county jail while they're working on their case, or they have really serious charges, but they haven't yet gone to CDCR. Lots of different reasons. People who are ineligible for diversion still deserve treatment. And it's time the Sheriff's Department developed acute and subacute facilities for those people. As we heard Supervisor Horvath say, right? That's not an abridgment of rights. That's a higher level of medically necessary treatment that people need in order to get well. And I can assure you, as long as I'm criminal justice chair in NAMI GLAC, we're going to be pushing for that. And the board is behind us on this. And we are meeting with the Sheriff's Department. We're discussing these issues. Will anything happen? I can't tell you. But the sheriff has talked about a campus care correctional facility. We got to figure out how to do it. Nobody wants to build a new jail with more cells. No one in the county wants to build a new jail. NAMI doesn't want to build a new jail. But we got to build something because we need to close Men's Central Jail, which means we got to take people with mental illness and put them in a therapeutic environment so the jail can be used for what it was originally intended for, right? Not for people who are sick. And we're going to be pushing that. I can't thank Caroline Goodson enough for coming here today. And she's great. And not only was her presentation fantastic, what she does day in, day out, every day, she's helping our folks. Okay, our loved ones with serious mental illness. Caroline, from the bottom of NAMI's heart, thank you so much.
thank you.
Give her a round of applause, everybody. She really deserves it. And thank you all for coming and attending.
And let's give Mark a round of applause as well.